Happy Thursday, everyone.
Hello, hello.
Hello, and welcome to Glad You Asked. Welcome,
Hey,
welcome.
Mike.
Hello, hello, hello. All right. Whew. It's a lot going on today. Today is June 30th. I hope everyone has renewed. If you hadn't, you got a few hours, but don't wait. System might crash. I always think of what's the worst that could happen, right? The system crashes at 11 p.m. So if you hadn't renewed, renew. And tomorrow's July 1. So what does that mean? Form changes.
Something's happening. Right.
Changes. Yeah, form changes. All right, so that's what we're going to talk about. Tiffany, what are our topics for the day?
All right. So our topics for the day include a few reminders, as Teresa just told you. Today is the day. If you have not renewed your license, tomorrow you will not have one. You will be an expired ex-real estate broker. And so make sure you do it and don't wait till 11 p.m. You got to get it done sooner than that, or you might get locked out. So license renewal. We're going to spend the majority of the time today talking about form changes. There are a lot of forms that have changed, and they will all affect you in some way, depending on what kind of real estate that you practice. So we're going to dig a little deeper, and we're going to actually show you a few of the forms and talk through what is changing and how that impacts and affects you and your business. And just a reminder, the forms change do go into effect tomorrow. And we ask that you start using the new forms right away. All right. And so, but before we go into form changes, a couple other reminders for you. Docusign Forms. Okay. So Teresa, we talked about this a little earlier.
We did.
And she has a warning for you if you don't use Docusign, but tell them about the Docusign versus the .loop.
Okay, so, KWRI no longer has the contract with .loop. .loop was it for KW several years ago, but now that contract has ended and we are with Docusign, Docusign will automatically upload the forms, the new forms. Now, it may not be tomorrow. However, if you need new forms and it's July 1 or even July 4th, who's working on July 4th? Anyway, if you need a form on the 4th, if you need one, and we would prefer if you start to use the new forms. And the reason for that is with these changes, I like for all of the agents to be consistent. Because what happens is if there's a transaction that takes place after July 1, I have to keep asking agents, okay, old form, new form, which one did you use? Depends on what applies, right? So if we just all start using the new forms as soon as we possibly can, I would really love for us to do that July 1. Again, they will automatically be uploaded into Docusign. However, it may take a few days for Docusign to upload all of the documents there. Now, with .loop, I was informed, I think .loop sent something out last year or I seen something come across where .loop will now upload the forms and change the forms and all that good stuff with the samples and all that good stuff. So if you're still using .loop, those changes will take place. However, with .loop, KW does not have any say-so in .loop. That's the biggest thing. So we will not drive any changes with .loop. If you use .loop as an agent, it's going to be up to you to get with .loop and kind of manage when those changes will take place. However, with KW, we're using Docusign now. So those will be automatically done. And those are the ones I can help you with. One other thing, last year, we had an issue when the new forms came out. We didn't have access to sample copies in Docusign right away. DocuSign did correct that. However, when they made the correction, there was a disconnect for agents. Their NCAR forms went away out of DocuSign, and it was a quick fix. I had to reach out to DocuSign to figure out how to do that. So let me just say that if you go into your forms after July 1st and NCAR forms does not show up, we got a problem, and it's probably something that I can call DocuSign and get the workaround for it. Of course, you all are realtors. So log on to ncrealtors with an S.org and log in with your NERDS, NRDSID, and your password, and you will have access to all of the forms. They are under the Business Center section and then the Transact section. Okay, so to access the forms prior to DocuSign and .loop uploading, ncrealtors.org. Okay.
All right. And as we mentioned earlier, you're going to see a few of these form changes today. We're actually going to take you through and show you some of the major things that have changed. But before we do, one other thing we wanted to run past you guys. You know, we try to keep you abreast of things that are happening out there in the field or with our agents, or give you some updates and things to be aware of. And so something that came up recently, and we just want to remind you all, you have to be very careful as a listing agent to make sure that you do not inhibit or decline an appraiser who's coming for the buyer to appraise the property. You don't realize when you do something like that, that you're actually violating federal law and potentially antitrust and a few other issues. So if you're the listing agent and a buyer has an appraiser trying to come and appraise the property, you don't have that authority to decline an appraiser just because you maybe had a bad experience with them, or you don't like something that happened in a previous transaction. So just be aware that if you do, then you are subjecting yourself to potential legal liability, we'll put it that way. And so be aware and make sure that you don't put yourself in harm's way, we'll say it that way.
Okay, Tiffany, but I have a question. I'm an agent. Okay. I'm the listing agent. And I can't decline, but heck, my seller is refusing to allow this appraiser or this inspector. I mean, my seller says it. I'm just following the lawful instruction of my client. What do I do?
Very good. So keep in mind that the point is that you have to follow lawful instructions. If your client is asking you to do something illegal, you do not have to follow that instruction. And so that's why it's really important to know what the law is and to inform and instruct and educate your client. And so, go ahead.
I was going to say, and oh, by the way, when your seller signed that contract, when they accepted it with their signature, they contractually bound themselves to that. They said that they will give reasonable access to it. So they could potentially be in breach. And guess what? There goes a whole nother set of consequences there.
Very good. And so again, make sure that you're aware of the laws and don't overstep your boundaries. All right. So we just wanted to give you that little heads up. That's just something recently that has come up. And wanted to let you know that we have some fun things in store for Glad You Asked here in the next couple of months. We're going to have a few guests. You guys have been making some requests and we've been working on those requests. Should I tell them?
You can give them I think so. They keep them coming back. Keep them.
Oh, yes. Back. We want you to keep coming. Right. Okay. So we are going to, in the next few Glad You Asked here, we're going to have several guests. We will have an appraiser coming to answer some of your appraisal questions. we've heard and we're working on that with you even as we speak. So of course you'll get the heads up of who the guest will be the day of the Glad You Asked, but just let you know, we're working on an appraiser and we are working on multiple county permit approval. So yeah, our permit folks that will explain the permit process and inspections and such from more than one county, because you all work in multiple counties and they are different county to county. So we are working on Alamance, Orange, and Durham County for the permit representatives. So we're going to be having some guests over the next several GYAs. And so make sure you come and bring your questions, the things that you need to know or want to know about appraisals and about the permitting process.
Exciting. Exciting. Yay.
At least I'm excited. I don't know about you guys, but I'm looking forward to it.
I'm excited. Yeah, okay. I am too. I love learning, and especially when things are changing. So I'm thrilled. Can't wait.
Stay on top of it. Make sure you stay compliant. This is for education as well as it's for all of our benefit to know and to continue to be on top of our field. And so if you are ready, let's jump into today's main topic. Are we ready?
Ready.
All right.
Ready.
Forms are changing, you guys. So there are 4 kinds of form changes that are happening. So we've got the residential forms, we have commercial form changes, we've got property management form changes, and what was the 4th one? I don't have that right in front of me.
Auction.
Oh, auction. Thank you. The auction. Now, in today's session, we're really going to focus primarily on residential, and we will touch briefly on commercial. Remember that KW Central does not offer property management, and nor do we hold auctions to my knowledge. And so we're not going to focus on those 2 topics, but you have access to all of those changes in your email you should have gotten from NC Realtors around June 21st with a summary of all of the forms changes, and there's quite a few. And so
and I wanted to say thanks, Tiffany. I see Carl is on. I don't know Carl. Hey there. Hey, Carl. If you use the standard forms or not, or if you use your own forms, there are some changes there. So take a look at those at ncrealtors.org.
Ryan's writing it down right now.
All right.
Awesome.
Yeah. Hey, Ryan.
There. Awesome.
And there are several changes. And so we want to make you aware. There are 26 changes on the residential forms, and there are 20 on commercial. So these are significant. They're primarily related to the same main topics that we're going to dig into today. But you want to be aware of the forms that are changing and how to use these forms and these changes. Today's session, we are primarily going to look at the offer to purchase and contract, and then the listing agreement. Okay, and so Teresa is going to bring up the new OTP on the screen as I talk through what these form changes are specifically for the OTP. There's a couple of main changes, but we're going to just kind of step through what the main changes are on the OTP. And I see you've got the buyer agency up as well. That one has changed too, but here we go. This is the one that we're going to talk through. So one of the first changes is right here in the beginning, paragraph 1C. Notice this new paragraph right about the middle of the page about manufactured and mobile homes. So now, right on the first page, there is a checkbox of whether or not this offer to purchase will or will not include a manufactured or mobile home. And so, because there have been a lot of questions about, well, where do we include it? How do we do so? If you do have a mobile home that's going to transfer with the property, it still refers you to that additional provisions addendum 2A11-T, and you would attach that with the offer. But now there is a checkbox right on the first page that identifies whether or not a manufactured or mobile home will convey. All right, so that's one of the very first changes right on the first page. Teresa, if you scroll on down, in paragraph 1D, you'll notice it's going a little fast. Go back up. Yeah, go back. Just scroll down just a tiny bit right here. So right here in 1D, you will notice that the initial earnest money, it can be made through cash, personal check, official bank check, wire transfer, electronic transfer. Notice that it just says within 5 days of the effective date of contract. There's no longer the option to pick either immediately or with this offer or within 5 days. That doesn't mean that you can't still send it in immediately or right away, but it has now just saying it's strucken out the option there, and it says just within 5 days of effective date. So just letting you know that you don't have to pick an option of when it's going to be delivered. Just know that it has to be delivered at least within those 5 days. So that has changed just to simplify, make it a little less confusing. And then also wire transfers have been added in the wording here as a means of transfer for the initial and additional earnest money. So we now have wire transfer as an option. All right. Now, if you'll scroll on down to paragraph 2B, this is one of the bigger changes that has happened. So 2B, here we are. This is where we're talking about what are or are not fixtures. Notice that our fixtures list looks a little more simplified here because they had a giant section on fuel tanks that's not here anymore. Notice that the fuel tank section has been removed from a bullet point in our fixtures, and they have created a whole section that talks about fuel tanks. Fuel tanks is the one topic that just keeps changing in the offer to purchase about every 2 years. And so they've made some new changes and have created a dedicated place in paragraph 7 for fuel tanks. So we're gonna it's missing here because it's been moved to paragraph 7. Also note while we're here, the swimming pool section, swimming pool, hot tubs, on the right-hand side, thank you. Notice that they exclude inflatables. There are more and more people who are using inflatable hot tubs, inflatable swimming pools. So those are mobile, those are movable. And so we have specifically excluded those in the contract now. So make sure when you're explaining this to your clients, they understand that inflatables are not considered to be fixtures and they will not remain or convey with the property. Okay. And then the last thing is about those doggone rods. You know, those curtain rods, like do the curtains stay or go? Or what about the rods? All of that. So notice here that they have changed the wording here in that last section. Window, door blinds, and shades are expected to remain. Curtain and drapery rods and brackets. They're still trying to just state that it's just the rods, just the brackets, not the curtains. So that is an attempt to try to clarify that just a little more. All right, next section is paragraph 2D. So just scroll on down a little bit here, right there. Items leased or not owned. You'll notice previously there were antenna, satellite dishes, receivers, appliances. There was also a reference to fuel tanks. Again, the fuel tank reference has been pulled out of there, and they do have a little sentence underneath. In addition, any leased fuel tank identified in paragraph 7D shall not convey. So they are being very specific here. Instead of making the seller remember if the fuel tank is leased or owned or any of that, it states that if the fuel tank is leased, it will not convey. It's just taking away that requirement for the seller to have to disclose it to be leased for it not to convey. Okay, so just making sure that there's more clarity and protection for both buyer and seller with regards to these fuel tanks. All right, so now the next change, scroll on down to paragraph 4A. All right, thank you. Now, under the note in paragraph 4A, the wording has been changed to more clearly state that there's no loan or appraisal contingency. Jen, I see your hand. You have a question?
Yes, I just wanted to know, and I apologize for not figuring out where my hand was fast enough. But on the fuel tank, if lease no longer conveys, then as a listing agent, do we now need to make sure that the company comes and removes the tank if it's a leased tank?
Okay, very good question. So the point here is really to clarify that the owner doesn't own it and they don't have the right to convey it. So as the real estate broker, you should still gather as much information, and you're the information conduit there as far as what does the buyer need to do concerning if they want to continue the lease, or if the lease will need to, or if the tank will need to be removed. So you're still going to do your part to convey the information, but the contract itself has been changed to make sure that it's clear that if a seller doesn't own the fuel tank, then they can't convey it. So that's really what they're trying to capture and correct in the contract.
Thank you for the clarification.
Sure. All right. So for 4A, notice in the blue note here, it's pretty straightforward there. There is no loan or appraisal contingency in this offer to purchase and contract. So they're really trying to make sure that that is crystal clear. They're advising the buyer to consult with the lender before and make sure the due diligence period is sufficient. But again, just trying to drive that point home that North Carolina forms, the standard forms, do not have a financing or appraisal contingency. So just make sure that you continue to educate your clients accordingly. All right, scrolling on down to 4B, subsection 11, XI. Again, in this whole section here, the fuel tank, the reference to fuel tanks is no longer there. So there used to be an 11. And again, that has been moved all the way to paragraph 7. And we're going to see in just a few minutes here how they have consolidated all of the fuel tank information. All right. Paragraph 4D, for clarity and emphasis, yet right here, notice that there's a couple of lovely bullet points to help the buyer and seller understand that unless the parties agree otherwise, the property is being sold in its current condition, in all caps. Do you all see that? This has always been in the contract. What was it?
I love it.
It's always been there.
I love it.
The wording hasn't changed. They just put it in a bullet point now to try to help people to really get it, you guys. This contract means that the property is being sold as is already, and they have to have some other agreement if they want to have repairs negotiated. So unless the parties agree otherwise, the property is being sold in its current condition. The seller may, but is not required to engage in negotiations for repairs and improvements. And obviously, in this market that we're sort of shifting out of right now, that was a big deal where sellers didn't have to, and they weren't even interested in making any kind of repairs. And so just a reminder, it was always a part of the contract that they didn't have to. And so they are clarifying and make it a little clearer by putting the bullet points there. But that wording was always there.
Always there. And therefore we should read them, agents, and explain them to our clients. Speaking to myself as well.
You're right. We should read it, and then we should definitely educate our clients, because they're probably not going to read it in as close detail as they really need to. Yes. So again, the purpose for this exercise. All right. So scrolling on down to paragraph 5D, under the buyer representations and section here. Oh, there we go. You'll notice the RPODs here. So 5D is for the RPODs, and whether the buyer has received the signed copy, if they have not yet received the signed copy, and the exemption. So what they're doing here is clarifying at what point that the buyer has or has not received the signed RPODs to help them understand when they're able to terminate the contract and get everything back, okay? And so notice that it says here or what they're attempting to do in this new paragraph here. They've added new wording where the buyer acknowledges the receipt of the disclosure statement prior to the making of their current offer. So what has happened is that there have been buyers who made an offer originally, and then they were doing some negotiations. And during negotiations, they received the RPODs, but they didn't get it before their original offer. So once negotiations have happened and things have changed, if they've received it, that is still considered to be sufficient to satisfy that they have received their copy of the RPODs prior to making this offer. Okay, so notice in that very first option there, it says that they have received a signed copy prior to making this offer, and they not acknowledge compliance. So not just prior to making an offer, but this specific one, in case they have a scenario like that where they got it during negotiations. So again, just trying to clarify, because all of these things, all these changes are happening because there have been real life issues in transactions, and they're trying to simplify. Teresa, did you have something to add on that one?
Just agreeing, just shaking my head in agreement. I'm good.
Okay. And then the same applies in 5E for the oil, mineral, gas disclosure, that they have received a copy of it before this offer, the current offer that is being agreed upon or signed. All right, so moving on down to paragraph 6B. So this is the buyer's obligations. So under 6B, there's some wording that was taken away to simplify, and it has been moved to a brand new paragraph that we're going to look at in a little bit, paragraph 9. So some of the buyer obligations and costs have been broken out and are going to be explained in more detail a little further down. So we'll see that when we get to paragraph 9. All right, now the one that we've been waiting for, this paragraph 7D. This is where they are specifically addressing the fuel tank issue. Now you'll notice this section here looks very familiar. What they decided to do was to take the fuel tank section out of the listing agreement and put it right into the OTP. So the seller representations from the listing agreement, they are also representing in the offer to purchase. And so it's not a huge change or a very scary one, but it's being very clear and transparent about the seller's knowledge concerning fuel tanks and about what the obligations are of buyer and seller accordingly. Okay, so you'll notice that whole first section, to the best of seller's knowledge, there is or is not a fuel tank. There's a section for 2 in case there's 2 fuel tanks on the property. Okay, now what's new here is under the double I, the tanks included in sale. Do y'all see that paragraph? That's new. The buyer and seller agree that any tank described above that is owned by the seller shall be included in the sale as a part of the purchase price, free of liens, unless it is excluded in paragraph 2E above. So anything the seller owns is considered to be real property that will remain. Okay, so it's very clear, very clearly stated. But again, if the seller is leasing it, it will not convey. That was already clearly stated back in paragraph 2. Now, the next section here was another bone of contention that they are again trying to clarify for buyer and seller, and that is regarding the fuel in the fuel tanks, okay? And so that now says the seller may use the fuel in the tanks described above through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as of settlement shall be included in the sale as a part of the purchase price, free of liens. So notice that the seller's use of the fuel in the fuel tank is still subject to their obligation to provide working and existing utilities through closing or buyer possession. All right, so now this really clearly identifies that the seller cannot take actions to try to remove the fuel and take it with them or resell it back to the fuel vendor Any fuel that is in the tank that the seller does not actually use in their usage of the property has to remain. Okay. Let me tell you, these sellers have been doing some crazy things when it comes to trying to get that fuel out, you know, and so to stop people from doing things that could potentially cause harm to the property, not let alone themselves, all about this fuel. And we know the rising cost of fuel, you know, people are getting concerned about that with, you know, fair cause. And so they're really being very intentional and specific about what will happen with these tanks and with the fuel. All right. Now notice that there are 2 notes that have been added under this section. The buyer shall be entitled to conduct their inspections to confirm the type of fuel tank, if there is one, anything about the fuel tank, and they're being advised to consult the owner of any leased tank regarding any terms that they could lease the tank and continue to obtain fuel. And then a second note that state law provides it is unlawful, it is illegal for any person other than the supplier or the owner of a fuel supply tank to disconnect, interrupt, fill the supply tank with LP without the consent of the supplier. Okay, and so just a reminder to these sellers trying to get their uncles and their cousins to go and put in a little bit of extra fuel if they need it to last till closing. They can't do that. You know, you have to have proper people handling the fuel that is going into these tanks. All right, so fuel tanks, that was really one of the biggest changes when it comes to how, what and how the seller's ownership and the fuel, how the fuel will convey and transfer. That's one of the most significant changes, but there's a few more. So are there any questions before we keep moving forward? That was pretty okay.
I was going to ask Jen, is that a new question or is your hand still raised from the last time?
Jen apparently has forgotten how to use Zoom. I apologize. I will take down my hand.
All right. Any other questions about that fuel tank? I personally think that that is an amazing change. I think it's going to be very clarifying for buyer and seller. And it really takes a lot of the opportunity for argument out of it when it's very clear. Mike.
Yeah, I remember the day where you could sell the fuel back.
Yeah.
No, that's been a long time ago, right? And or the buyer would have to pay for it.
Yeah.
I mean, so I love this change. It very much makes it very clear what happens. So that's great.
Yeah, I think a lot of these changes are actually very clarifying. And I really think that these are probably some of the better changes that I've seen in these forms as we are continuing to go through. A lot of clarifying changes. Yeah. All right. And so moving on here into the seller obligation section, the next change is in paragraph 8J. So when we're talking about, scroll back up just a little tiny bit. There we go. The owner association. So this is the second really significant change of this contract. And so notice 8J has been really simplified because they have decided to do a whole section that breaks out seller responsibility for HOA charges and fees and things and buyer's responsibilities together. So now 8J, they have taken out some of the previous wording there, and it's going to be down in paragraph 9. So now it only says that the seller shall pay any charges by an owner association or management company vendor as agent of the association under paragraph 9A. And so 9A will specify, it still has charges that the buyer is responsible for, but it's very specific and very clear. And so that was a really significant and helpful change. And then scrolling on down, paragraph 8N, the old paragraph 8N has been removed and replaced with the home warranty section here. And so they put what used to be section number 10 under 8N. And so the seller either is not going to, or the buyer can obtain and have the seller pay for the home warranty. That whole section that used to be number 10 is now part of the seller obligations under 8N, but still the option of whether or not they're going to offer one. All right. And so now paragraph 9, notice this is a lovely new paragraph that specifically talks about what the seller shall pay and what the buyer shall pay concerning owner association charges. All right. And so notice the seller shall pay any fees incurred by the seller for completing the RPODs, resell other certificates, fees required for confirming their account, association dues assessments, prorations, anything that's charged in connection with providing that information. That's a seller expense. Any fees charged for transferring or updating the ownership records charged to the seller. Any fees other than those specifically required to be paid by the buyer below are going to be paid by the seller. And so again, very, very clear. The seller is responsible for all the fees except for 9B, these 3 specific fees that the buyer is supposed to be responsible for. And so what does the buyer have to pay for HOA? Charges for providing information required by their lender. So if their lender requires something, that's the buyer's expense. Charges for working capital contributions or membership fees or charges imposed for the buyer's use of the elements or services provided to the buyer in connection with them taking possession of the property. So there are some HOAs that charge a one-time capital contribution for new owners and things. Any of those kinds of fees that are for new owners or for the buyers, they are responsible for. And then any charges for determining restrictive covenant compliance. So if the buyer wants to, during their due diligence, determine if they can do a certain thing with the property, if there's a fee for that, that is the buyer's expense. Other than that, all the other transfer fees are now clearly the seller's responsibility. Okay, so again, no room for argument there if it's not specifically listed. It states here, any fees other than those specifically required to be paid by the buyer under paragraph 9B below are the seller's responsibility. Okay, so again, another very clarifying change that will help us as brokers, I do believe, in navigating through some of the sticky areas that buyers and sellers have previously had a problem with. So now the new paragraph 10 it continues on. It's the prorations and adjustments as previously listed. In paragraph 11 here, 11 has been clarified. And I'm so glad because, you know, previously it was understood that if there was a damage to the property, that the seller had to return the earnest money, but that it didn't specifically say that they had to return the due diligence. So the understanding is if the property was damaged, that the buyer should be made whole again, but it did not specifically state that in the contract. Well, now notice number 11, it has been broken into a section A and B. So section A is the condition of the property at settlement, and then B is risk of loss. So notice if the property is not in substantially the same or better condition at closing as on the date of the offer, reasonable wear and tear accepted, the buyer may terminate this contract by written notice delivered to the seller, and the due diligence fee and earnest money deposit shall be refunded to the buyer. So that omission previously there has now been remedied and corrected. So it's clearly stated that the buyer does in fact get back the due diligence fee and the earnest money. Okay, so that's a huge change in the fact that it's stated in the section now. If the property is not in such condition and the buyer does not elect to terminate the contract, the buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by the seller on account of damage or destruction to the property. So that part is the same, but the significant part here is the specifically stated due diligence fee along with the earnest money being returned. And then of course, the risk of loss is always the seller's responsibility until that property has closed/recorded. And so the sellers advised not to cancel their insurance until confirming the deed has been recorded. All right. So again, another very significant, very important change that I think was long overdue So glad that they finally caught that and got that updated. So now, Teresa, you can scroll on down to the bottom. Everything else is the same as what you know and love as far as your contract goes, all the way to the last section, paragraph 23B here. Now, notice that this has also been broken out into a few different sections to help to clarify a few things that have been issues here lately with buyers and sellers. So the breach by the buyer, the breach by the seller, and attorney's fees have all been captured under this new paragraph 23 that is specifically dedicated to remedies. All right. And so here, the wording that has changed is that the buyer's right to sue for specific performance is specifically stated here. So it's understood that the buyer has that right, but it wasn't actually previously stated in here as a part of the rights of the buyers if the seller breaches. And so notice that that last statement there, or the last sentence under B, the buyer, in addition to the entitlement of the return of their earnest money due diligence fee together with reasonable costs actually incurred by the buyer, they can or elect not to terminate and instead treat this contract as remaining in full force and effect and seek the remedy of specific performance. So it's actually stating in the contract that they could be made whole again, get everything back and terminate, or they have to keep the contract in full effect and pursue the specific performance. So it's really clarifying that they have those two options in writing. And so again, that's really helpful, very clarifying for both buyer and seller on what the buyer's rights are if the seller breaches. All right, so any questions about that? Those are the main changes in the offer to purchase. Again, pretty significant, but all very clarifying. Any questions about that? Nope, no questions. Everybody good? All right, good. Very good.
Yeah.
All right. Now, I mentioned to you guys a little earlier that there were a total of 26 changes. Now, while there are 26 form changes, many of those form changes are related to the things that we just covered specifically here. The fuel tanks, the HOA dues, just in other forms where they're also referred to. So a lot of the other form changes are related to those changes that we just covered in detail. But there are a few other things that I do want to point out to you that are changing that are not related. Okay, and so the next thing that I want to talk about with you are the changes to a couple of the other addenda. So we're not going to actually pull up all these different addenda and show them to you. The only other one I'm going to have Teresa pull up for you is the listing agreement, but we're not ready for that yet. So Teresa, if you want to just go back to the main screen where we can just see everybody, I'm going to talk you through a couple of changes in the addenda that I just want to point out and make you aware of. Okay. And so the first one that I want to point out, again, go back and read over all the changes, but one that I want to specifically highlight is if you use the new construction addenda. The new construction addenda is something that you can add on to the offer to purchase if the builder doesn't have their own standard forms and they want to have a new construction being sold. There have been a couple of changes to that one, mostly minor, to make sure that it's understood what the purpose of that form is. But one of the biggest things is that the warranties and insulation of the house, those are required. They are required to be disclosed to a buyer in a new construction scenario. And so they're wanting to clarify that this addendum does need to be used in the case of new construction. And so if there is something that needs to be, if all the other terms of the new construction addendum don't apply, you still need to use the addendum specifically for the warranty and the insulation disclosure. Okay. Otherwise, if you're just using the contract, there's no warranty. If you don't have this addendum connected to it, it does not include the required 1 year and minimum of 1 year warranty from that builder. And so it's designed to make some changes to help people to understand that this addendum is vital because it includes the right to that buyer to have at least a 1 year warranty and the required disclosure concerning the insulation values. All right, so make sure you review that if you're dealing with new construction. Katie. Mm-hmm.
I'm sorry, this may be a really ignorant question. So if you have somebody who, let's say that the house is already built, like it's there, but it has not been lived in. So essentially it is new construction, but it's not being built while you're under contract. Do you use the normal offer to purchase, or you still need to use the new construction data that you're speaking of?
So what I'm saying here, whether the house is already built or if it's already in the process of construction, you would still use the standard offer to purchase, but then you want to attach this new construction addendum to it. And the new construction addendum can be used if there's going to be some small changes made to the home or in the build process, or even if there's no changes, you still want to include this new construction addendum so that your buyer will have the protection of at least a 1 year warranty.
Okay.
And because disclosure is required concerning insulation.
Okay.
Okay. Thank you. Good question. All right. Now notice there's several addenda that have changes. Most of them are pretty minor changes. The next one I really want to point out to you is the buyer possession before closing agreement. Okay. And by the way, I just heard a nightmare from an agent this morning about, what happens if the nightmare was the seller possession after closing. Well, the seller's builders delayed. Now this buyer can't move into her new home because the seller is still trying to stay there longer and all that. What are your responsibilities? Well, remember, your responsibility as far as the contract is concerned ends with the contract. Those are agreements between buyer and seller directly, and it's not your job to help them negotiate through all of that. So you got to help them understand their liabilities prior to entering into that agreement. But anyway, back to the buyer possession before closing agreement. There's a couple of changes. There's been a warning added. And so the warning has been amended to specifically mention security deposits, because that buyer possession before closing agreement is designed to be short-term and it does not include a security deposit. Well, now we're suggesting if somebody's going to possess the property who doesn't own it, it might be a good idea to include a security deposit. And if you decide to do so, then you really need to use a residential rental contract that includes the security deposit and where it's going to be held. So that would just be protection for whoever is the owner of the property when someone else is residing in it. Okay. So there's a reference there to point people that direction for better protection for whoever's going to be owning that property in this possession agreement. All right. Now, in paragraph 1, there's been a new paragraph added to give the seller the right of access to the property for emergency, and to clarify that all means of access to the property are to be delivered to the buyer at the commencement of that buyer's possession, with the seller being entitled to retain an entry key. So if the buyer is going to possess the property before closing, they have to give full possession, everything, the garage door openers, all access codes, all of those things at the time that the buyer is possessing the property. And they are only entitled to retain one key to enter the property in case of emergency. So that's been clarified, what has to be transferred to whom. And then, of course, the opposite of that is true in the seller possession after closing agreement. And so both of those agreements have been clarified to say how much possession, how much access to the property the owner of the property has versus the person who has the right to possess it. Okay, so be aware, make sure if you're going to use those agreements that you read over the new form carefully and that you explain that to your clients. All right. And then finally, the other one that I wanted to point out to you, again, there's still some other changes. You should go and read over all of them, but the agreement to amend the contract. This is document 4T. Notice that agreement to amend includes things like if you need to extend the closing date, if you need to change the closing costs, you know, it's used for several things. Well, what they have done there is that they have put a blank at the very top of the page where you can put the amendment number, because sometimes there's several amendments to a contract. And so maybe you use it first time for extension of the closing date. You might use it a second time to adjust how much the seller may be paying in closing costs or something. So you can now have an amendment number to make sure that all the amendments are kept track of and provided to the lenders and the attorneys. Okay, so that's a really useful change that they made. And then the other change, this one's also wonderful, is that there is now wording on that amendment that the escrow agent, there may be the authority to release the earnest money to a successor escrow agent. How many of you all had a contract where the buyer changed their mind, wanted to use a new attorney or something to that effect? And then they're always saying, do we have to change the contract? What do we have to change? Well, now all of that has been resolved because there is now a section in this amendment for a successor escrow agent. And so if the original escrow agent is holding funds and the buyer has changed attorneys, this is how you can release those funds from the original escrow agent and release them and name who the successor agent is. And so again, you know, they're listening, they're hearing the issues and confusion, and they are making some really useful changes in these forms. All right, so that's it for the offer to purchase and for the addenda. And then the only other form that we were going to go over or show you the actual changes today are the actual listing agreement. Okay, now the review of the listing agreement is going to be very quick because it's all related to, again, the changes that we already well, not all, most of it's related to what we already discussed in the offer to purchase. And so in these paragraphs, as we are going through this, I'll point out things that we've talked about already. So the first thing is paragraph 3B in the listing agreement. You'll notice paragraph 3B, it has changed, it's been changed to match the new list of fixtures that are in the offer to purchase, which we've already talked about. Okay, then moving on along here, the next change is paragraph 3E. Also, yep, that has also changed when it comes to items that do not convey or to be excluded. When it talks about it removed the reference to the fuel tank, because that's going to be later in the document. Paragraph 7F, it used to be fuel tanks, I do believe. What was 7F? Oh, no, 7F is talking about, that's compensation. They have stricken what used to be in 7F and they moved it to paragraph 18. So we'll get there a little bit later, but they've just moved it to a better place that makes more sense in the document. Now, the next change is paragraph 12N. 12N is where the changes to the fuel tank, this is what we should see. The fuel tank changes from the, yeah, here we go. Yeah, so we're in 12 and there's N. So the same thing that the seller is disclosing here in the listing agreement, again, the same disclosure is what needs to transfer over into the OTP now. And so it's been updated to match. So these should be identical, what you see here in the listing agreement and now in the offer to purchase. All right, now this is an interesting change, paragraph 14. In paragraph 14, the acknowledgement of the Q&A on home inspections, you notice that that used to be a checkbox there. So that has changed to an advisement that they have a home inspection, and then they either choose to agree or not obtain a home inspection. But notice the checkbox that say that they've received the Q&A brochure has been removed. Okay, so they took that out, and instead in paragraph 20, they're going to refer the seller to all of the Real Estate Commission's brochures and things. So you no longer have the checkbox to say that they've received the Q&A on home inspections. Okay, so that's good news for you guys. One less thing you have to keep up with and try to get or provide to them. Now, the big changes are in 17, dual agency. Oh, Tara, I see a question before we go into dual agency.
So does that mean we don't have to send them the Q&A, or we should still send that Q&A?
Okay, good question. So you're not required per this document to have to provide a copy, but they are going to point the seller to the Real Estate Commission's website to get all of their Q&A.
So it's not as many documents you have to send to them. Is that correct?
Mm-hmm.
Okay. All right. Thank you.
You're welcome. All right, number 17. So when it comes to 17, what you'll notice that this is where we explain dual agency. So the dual agency information is still there. The firm's role as a dual agent, the seller's role. What changes is down here in section D. So take a look at paragraph 17D. Scroll on down a little bit more. All right, so this is where we're picking designated dual agency. So previously there was a section, you know, where you had to have the seller to authorize exclusive or dual, and then they had to have a subsection for the designated dual. Well, they still have all of that there, but what they've got now is it makes a little more sense how they do it. If they're going to authorize dual agency, they have to authorize that first before designated even becomes an option. So they have very clearly, they have to pick between dual or exclusive. And then if they pick dual, then the seller does or does not authorize the same individual agent to represent both the seller and buyer in a transaction. So they can choose within dual agency if they will allow the same agent to represent both, or they have the option to initial here. If the firm offers designated dual agency and the seller authorizes it, then designated dual agency will apply and they can initial there. So remember, in just plain dual agency, you could have an individual agent represent both, but that can't be the case in designated. So if they do or do not authorize the same person in regular dual, or are they going to authorize the full designated agency? All right. And so it really is very helpful in explaining what it even means and what the options are for buyer and seller when it comes to both dual and designated. And I see a lot of chatter in the chat here. Everybody's really excited. Yeah, anything that helps explain agency a little bit better is always useful and helpful, especially dual and now designated. So I love how they have broken this out. It's very clear and it helps you to have some talking points to explain it a little further to your clients. All right. And so that was the last big change on the exclusive right to sell agreement. Let's see, what was the last one? Oh, paragraph 18. Let's scroll on down to 18. There we go. That has also changed to match some of the, well, no, not to match the OTP, but this one talks about termination when it comes to the listing agreement. So it talks about termination, what happens in that case, what happens separately if there's a breach of the contract, then it breaks down mediation, and then it also refers to attorney fees and who will be responsible if there has to be legal proceedings concerning the listing agreement. And so they have really broken them down into individual sections to explain what happens in the event of a termination, a breach, if mediation is needed, and if there are attorneys involved. All right. So again, just clarifying, really simplifying, making these forms better and easier to use. All right. So those are the big ones that we wanted to make sure that we highlight and point out to you. But again, many forms are changing. As far as commercial forms go, I know we got a couple of commercial folks on here. There were 20 changes. One of them is that there is the working with real estate agents for lease transactions. The one for tenants is now finally available to you. If you need that form, that's something that people have been asking for some time now. But there are several form changes, most of them fairly minor. So again, any of the forms that are on that list that you use in your business, please be sure to carefully read over them and be familiar with what has changed and how to explain that to your clients. All right, well, we want to thank you all so much for attending. Any questions before we go? Okay, I see a couple of, okay, I see Mike and Carl, okay?
So go ahead, Carl.
My question is there a place to go that tells you what, not necessarily everything that changed on the form, but looking at it, is there somewhere on the site that says, hey, these forms changed, you should go look at it?
Yeah, there's a document that the NC Realtors has created that gives you a specific list of what forms change and what the changes are. That's what I was just using and referring to for this review here. You should have gotten an email from them. You see that Teresa's holding up. You should have gotten an email from NC Realtors on June 21st. So go back and check your email and it will give you a link to all 4 types of document changes and the full summaries for all 4, including property management, because I know that that might be significant to you. So they have a lovely document that summarizes all of them.
And one other quick question. This is a little bit for, I ask it after he asks his question.
Okay, Mike?
So mine refers back to the fuel tank situation. How is there anything, and I can't recall on the RPD, but was there anything added to the RPD where they can include the fuel tank information, or are we going to have to put that on MLS?
Okay, good question. The RPD, I don't have any reference to that document changing. So I don't know if that will be a change in the future as a result of this. But when it comes to the fuel tank, the disclosure, all the information that you have is material fact anyway. So you would have had to disclose it however you disclose your material facts.
Okay. Thank you.
You're welcome. All right. Any other, Carl or Teresa?
Yeah, I was just going to say the RPD, RPOS is handled by the commission and not the Association of Realtors. So I don't know if they're going to coincide or not. But like Tiffany said, it's material fact. So we got to disclose it even if they don't. Seller doesn't. Good one. Carl, your turn.
Yeah, this is a little bit different. This is for paying the $45, get renewed for your license. But I paid the $45, but Ryan mentioned that other fee that we had to pay. I thought I've only paid it one time in 2019. He said he gets the bill every year. Does anybody else pay? I see shaking and no. So what's the answer?
Privilege license
Yeah, the privilege license.
That's what he's talking
every
about.
year.
Yeah, so that's due every single year.
I paid it one time, 2019.
Yeah. And see, I won't say the sad part, but I guess for the lack of a better word, the sad part is you may or may not receive it from the North Carolina Department of Revenue. Please check when you check your mail, and I mean physical mail in your mailbox, you will get a letter from it says NC, can you send me my form over there? NCDOR, North Carolina Department of Revenue, every year. Now, here's the thing. If you do not pay it, if we do not pay it, thank you, Jan, she put it in the chat there. If you do not, this is what it looks like there. NCDOR, Department of Revenue. I think I got this May 27th here. Because I am big here, I received this one here. It's due every year. The thing about it is, if you don't pay it, and when you file your taxes, and you just so happen to get a refund, did anybody get refunds anymore? I don't have any kids and I'm self-employed. I don't know that I've got a refund. They will take it out of there. And even if you don't get a refund, that then becomes part of what you pay. You will pay them. Right, Katie? And they will tack on interest. So go to NCDR and you can pay.
Well, Ryan's feeling special because he was right.
Yeah. So you guys, we do apologize for running over just a little bit here, but there's a lot of really important information that we needed to cover with these form changes. Again, we have some exciting things coming in the future. If you do have any questions about what's happening in your transactions, if there's something happening that you need advice on, make sure that you email us at brokerincharge832@gmail.com so that we can give you specific guidance on what's happening in your actual transactions. And we just want to say thank you all for attending, and we are
so glad you all asked. Yay. We'll see you in 2 weeks. 2 weeks. 2 weeks.
Yep. See you soon.
Bye, everybody. Happy 4th. Happy 4th.
Oh yeah, happy holidays.